Record to the cloud. Okay, fabulous. So tonight we're talking about the judicial branch. Again, you may recall from the very first day, the very first guest lecture, we had I just met with Corey Botts at Senate Labor. Sorry, Corey Jasperson, who is the Director of Government Affairs for the California Judicial Council. And as you may recall, they are the policy-making body for the California courts, chaired by the Chief Justice and a number of appointees, including some public members. They're sort of the state equivalent of the federal AOC or the Administrative Office of the courts. So I wanted to sort of cover the things that I care about when I talk about the judiciary. And excuse me, and I think like last night, I want to first run through in comparing and contrasting the state and federal, since many of you have some familiarity or exposure perhaps to the federal court system, sort of walk through the major provisions and certainly in the Constitution. So remember, it's Article 3 in the federal Constitution are the federal court systems, and then Article 6 in the California Constitution. So just like the federal government, we all 50 states have a judicial branch, one of the three branches of government, and obviously those court systems are separate. The federal courts focused on the federal body of law and the federal constitution, and the state, of course, determining questions of state law, state constitution, etc. Article 3 of the U.S. Constitution contains three main sections. One is the same sort of Section 1 of the California Constitution, Article 6. Remember, I mentioned last night, Article 4, Section 1 vests the legislative power in the legislature, and the people hold some of the power by initiative and referendum. Article 5, Section 1 grants the supreme executive power to the governor. And then Article 6, Section 1 uh, grants the judicial power in our judiciary. So the same Section 1 of Article 3 of the federal Constitution vests the federal judicial power in the Supreme Court in what the U.S. Constitution calls the inferior courts. Those are the lower courts. Just like at the federal level, Supreme Court is highest, Court of Appeal below it, and then the trial court, which we call district courts at the federal level. California, Supreme Court, Court of Appeal, and then what we call superior courts. We used to have two types of trial courts, superior and municipal, but about 20, 25 years ago, we merged them. And so our trial courts are called the Superior Court, again, District Court, U.S. District Court at the federal level. Yes, there are some differences. The most notable one is New York. For some crazy reason, I never heard an explanation, but the trial court is called the Supreme Court in New York State. Again, I have no idea. An interesting thing, both California and the federal courts technically don't have term limits for judges. The difference is at the federal level, whether it's the trial court judge in the district court, Court of Appeal judge, or one of the 9 Supreme Court justices, is that they basically have tenure for life. That's clear at the federal level. At the state level, it could be. Um, Judges at the appeals court, Court of Appeals, and the Supreme Court stand every 12 years for what's called a retention election. So technically, there is a check on them, but assuming they pass, if you will, by the voters, i.e., they are retained, they have potentially lifetime tenure. There is no retention election at the federal level, so that is a pure lifetime appointment, absent them, stepping down of their own volition. In Section 1 of the federal Constitution, it establishes the Chief Justice, but not the size of the Supreme Court. There has been talk in the past, especially when President Trump in his first term was able to appoint 3 justices. There's been talk ever since then about expanding the size of the court. That is done by statute. It is not set forth in the Constitution of the United States. It simply says that there shall be a Supreme Court that is led by a Chief Justice, but it doesn't specify the size. So that is up to Congress. They could, in theory, reduce it or they could expand it. So there has been talk from going from, 9 to 11 or 13, for example. Um, Congress has also established 13 courts of appeals um, across the United States. California and a number of the western states, including Hawaii, Oregon, Washington, Arizona, New Mexico, are all part of the Ninth Circuit Court of Appeal. There are 94 U.S. district courts, plus there are a couple of specialty courts at the federal level. The U.S. Court of Claims, the U.S. Court of International Trade, and the U.S. Bankruptcy Court that handles exclusively bankruptcy cases. Section 2 of the federal Constitution sets forth the powers of the federal courts and their jurisdiction. Generally, it's deemed to those that arise out of the federal Constitution or federal laws, treaties, cases involving multiple states or foreign governments, and some other specialized areas, such as bankruptcy, international trade, etc. Juries are required to be used in federal criminal prosecutions. And then the last section, Section 3, talks about treason, which is interesting, but that is under Article 3 of the federal constitutions. California and all 50 states have a state court system. They all have a high court. Again, the vast majority call it the Supreme Court, like California. They all have some sort of intermediate or appellate level, and then they all have trial courts. Again, we call them superior courts, others call them circuit courts, some call them district courts. There are also a number of specialized courts at the state level. The 2 most common are family courts and probate courts, handling, of course, wills and testaments that those after people pass away. So Article 6 of the state constitution, turning to California, there are 23 sections. Interestingly, the highest number of 22 is 22, but there are 23 sections in it. Section 1, of course, says the judicial power of the state is with the Supreme Court. While the federal says and inferior courts, we actually name them Supreme Court, the courts of appeal, and the superior courts. Section 2 of Article 6 specifies that there are 7 Supreme Court justices. So again, remember the state constitution says 7. So if you wanted to reduce the number or increase the number, of course, you would have to amend the California Constitution, right? But that is, again, not the case at the federal level. The federal level just says there is a Supreme Court, not with the number. Section 3 requires the legislature to divide the state into districts, each of which has 1 or more courts of appeal. So we have 6 districts. In Sacramento, we are in the 3rd District Court of Appeal, commonly referred to as the 3rd DCA. So we have 6, and then we have trial courts under those. So we have a Supreme Court throughout the 58 counties in the state of California. It's divided into 6, basically one up here, two, three, four, five, six in Southern California. Okay. Section 4 says that every county, so there are 58, of course, must have at least one superior court of one or more judges. Now it is up to the legislature. So the legislature is granted the power in Section 4. Remember that first, no, sorry, it was the second guest lecture, Ann Patterson from the governor's cabinet secretary. She talked a couple of times about separation of powers, but note that there's crossover even in the um, the articles. So, for example, in Article 4, the legislature, it has that the governor signs or vetoes bills. It has the governor can call them into special session. It has the provisions related to the governor introducing a budget, even though Article 5 is of the governor, right? So, like Article 6, which is all about the judicial branch, it says that the legislature prescribes the number of judges and other officers and employees for each superior court. The Judicial Council, again, that Corey Jasperson is from, is actually specified in the state constitution in Section 6. And that council appoints the administrative director of the court, so sort of like there's a director of the AOC at the federal level. There are some other entities that Corey briefly mentioned that we'll talk about a little bit more in detail this evening. But Section 7 is the Commission on Judicial Appointments. So we'll get into that, the role of that commission. And then the Commission on Judicial Performance is in Section 8. The State Bar of California, which licenses and regulates all attorneys in this state, is in the state constitution. I made that point briefly last night, noting that Stanford University, the University of California, and some other entities are in our state constitution. The state bar, a regulator, is in the Constitution in Article 6, and it specifies that everyone who is licensed to practice law has to be a member of the state bar. Section 10, again, of Article 6 says that the Supreme Court, the intermediate court, and the trial courts and their judges have certain jurisdiction over specified types of proceedings. Section 11 says that Supreme Court has appellate jurisdiction in any death penalty cases. So if a trial in the Superior Court results in a death sentence being imposed, it automatically goes to the Supreme Court. It doesn't go to the Court of Appeal. It goes to the Supreme Court. Section 12 specifies some of the jurisdiction of the appeals courts. Section 15 talks about who's eligible to be a judge. So remember in Article 5, Section 4, I think, maybe it was 3 or 4, describes the requirements of the governor. In Article 4, that we'll get to in the fourth course, it specifies the requirements for being a member of the legislature. Well, as you might imagine, there are some minimal requirements for being a judge in this state. You have to, in at least 10 years immediately preceding your selection, you've been a member of the State Bar of California or served as a judge of a court in the state of California. Section 16 says that the judges of the Supreme Court and the Court of Appeal are basically subject to these retention elections. And Section 16 does say that there's a 12-year term, but again, that's when they stand for retention. If you've ever heard of former Chief Justice Rose Bird in the 70s, in the first Jerry Brown term, lots of people incorrectly say that she and two other justices, so 3 of the 7, were recalled from office due to their opposition to the death penalty in the state. That is not correct. They were not recalled. It's a misconception. They stood for their 12-year retention election, and they were not retained. So they were not recalled. That is different. That's a removal from office. They were not retained. And usually, of course, recall means it happens before their term is scheduled. So they just didn't get another 12 years is what technically happened, but they were not recalled. In section 17, it prohibits a judge, as you can probably imagine, at the trial or appeals court levels from practicing law. And they're also ineligible for any other public office or public employment. They can only be a member of the judiciary. Now, there's one major exception, and that is teaching. Judges are allowed to teach. Section 18 discusses disqualification of a judge in certain types of proceedings. Then there's this one anomaly, section 18.1. That's the Commission on Judicial Performance and talks about their oversight and discipline of judicial officers. Section 19 empowers the legislature. Again, here they are. They prescribe the compensation for all judges. That's, of course, done in the state budget. So that also requires the involvement of the governor. But judges or an independent panel, they don't set the compensation of judges. It was mentioned briefly by Katie Monday night, but I'll reemphasize it that the elected members, so our constitutional officers and our 120 legislators, the Citizens Compensation Commission sets their salaries. Judges' salaries are set by the legislature. Section 20 requires that the legislature has to provide retirement benefits for judges. And then the final section 22 says that the legislature provides for other types of officers, such as commissioners, to perform what are called subordinate judicial duties. Now, let's turn to how judges are selected in California. The U.S. Constitution, I'm sure as most people are familiar with because it makes national news. Federal judges, whether they're trial court, i.e. the district court, courts of appeal from the 9th Circuit that we're in to the highest, the 13th. They're all nominated by the president and confirmed by a majority of the Senate and can hold tenure for life. The only way for them to be removed is through impeachment. The House impeaches, the Senate removes from office. And they're allowed to be removed from office for basically misbehavior, if you will. Now, state court judges are selected in different ways, including election. The main one is appointment by the governor. So the general rule is trial court judges are elected in California. Most vacancies, however, are filled by the governor, which is the authority granted to the governor. So the governor can appoint superior court or trial court judges whenever there's a vacancy. That's how the vast majority end up being a trial court judge. For an appellate court judge, that's the Court of Appeal or the California Supreme Court. The governor appoints them, but there is a commission that confirms. So it's not the Senate like at the federal level. The check is on what's called the Commission on Judicial Nominations, affectionately known as the Jenny Commission for the JN, the Jenny Commission. And that is 3 people: the Chief Justice of the Supreme Court, the Attorney General, and a Court of Appeal justice that is not on the same appeals court. And there's some other things for when it's a Supreme Court nominee, et cetera. We've talked a little bit about the jurisdictions and stuff between them. The other part that I wanted to chat about and that we talk about in the practical guide is the fact that obviously there's a role for the judiciary in several areas, including the lawmaking process, as weird as that may sound, but also because they review statutes, but they also review regulations and other things. So at both the federal and state levels, the judicial branch acts as part of that check and balance system, right? So a bill goes after it passes the legislature, it's not done, right? The governor or the president signs or vetoes it. There's still another check, and that is from the judicial branch. And if challenged, that statute is reviewed by the judicial branch to determine whether or not it, meets constitutional muster, et cetera. So whenever a California statute or a regulation is challenged in court, they're basically establishing policy, right? Um, so the courts at both the federal and state levels do play a role when they determine whether or not a California statute or a regulation potentially violates the federal or state constitutions or federal statutes. And of course, they interpret as well, right? So they don't just determine the legality of a statute or regulation, they also interpret what do the words mean of that statute or regulation. And statutory interpretation is probably the primary role of the judicial branch when it comes to the lawmaking process, right? Again, when they're interpreting statutes or regulations. Um, I just want to cover, let's see, on choosing judges, I think, trial court judges, if they're elected, they serve a 6-year term is their election. Wait, hold on a quick second. Sorry. Okay. Sorry about that. Um, it's a per the Constitution, just like local races, city council, mayor, supervisors, school boards, judicial elections are pursuant to the Constitution, a nonpartisan race. So even if we know the um, party affiliation of a judge, just like somebody running for mayor or city council, they don't run with a partisan affiliation. There is no party affiliation, D or R, or independent or whatever listed on the ballot, as opposed to obviously legislators, members of Congress, the constitutional officers, et cetera, et cetera. There are about 1,500 Superior Court judges in California, close to 100, I think it's about 102 or so courts of appeal justices. And then, of course, we have 7 members. So not 9 like the U.S. Supreme, but 7. Judges at the trial court level begin on the first Monday after January 1st, if they're elected to that position. For the appeals court justices and the Supreme Court, their terms begin when the Jenny Commission, remember the Commission on Judicial Nominee Evaluation, has filed its approval with the California Secretary of State, which is generally within a day or two after their hearing and determination. Okay. The role of the Jenny Commission is to investigate the nominee's background and their qualifications, and they hold a public hearing. and they actually rank the nominees by the governor. And they have four levels of ranking, and those rankings are provided to the governor. Now, the rankings don't bind the hands of the governor. It's simply a decision of the Commission on Judicial Appointments. So the Jenny Commission does a background check and evaluates their, uh, qualities for service. And so they have a low level up to a highest, four levels. But again, that doesn't limit the governor in who he or she wants to appoint. And it also doesn't bind that three-member commission on judicial appointments chaired by the Chief Justice. So even if a nominee got the worst of the four rankings, it doesn't preclude their nomination, nor does it preclude their confirmation by the Commission on Judicial Appointments. Okay. Um, on that 12-year election retention, when there's a vacancy, the the appellate court justice faces a retention election whenever the next gubernatorial election is. So believe it or not, if someone were nominated, and they will be earlier this year, later this year, to a court of appeal, one of those six districts in the state of California, they'll actually have their first retention election next year, 2026, because that's when the constitutional officers, including the governor's office, are up. And then after that, they'll have the next one 12 years after. Okay. So if you're in the first year of the governor's term and get appointed to the Court of Appeal or the Supreme Court, you'll wait 3 years before your first retention election, and then you'll have a second one 12 years thereafter. So you'll actually have two retention elections in 15 years in that election. All right. Um, Ann Patterson talked about this, but in light of the fact that we are studying two of the branches of government, the third later on in the fall, she mentioned, and I want to chat in a little bit more detail on the separation of powers doctrine. Remember, this is part of the check and balance system. And it basically says that our powers under our state government are divided into three separate but co-equal branches of government. Now, it's interesting that this doctrine is set forth by the U.S. Supreme Court at the federal level. Because if you look for separation of powers, you won't find it in the U.S. Constitution. You do in the state, Article 3, Section 3. So we have our separation of powers. It is in the California Constitution. So it's not a court determination like it is at the federal level. It is set forth in our Constitution. And basically, what it says is that each of the branches can exercise the power granted to their branch and not the powers of the other two. Now, as you can probably imagine, since we've touched upon a few of them, the Cal Supreme Court, despite the explicit separation of powers doctrine enumerated in our state constitution, the court has said that they do exercise a little bit of each other's powers, right? For example, we know that the executive branch does do some lawmaking through regulations. Some of those agencies, as we talked about last night when we covered administrative agencies, we mentioned that they engage in some quasi-judicial stuff, right? They interpret statutes and give legal guidance to those that they, for example, license and regulate. So the California Supreme Court has, while they recognize the doctrine, they also recognize that there is some instances where the other branches may put a toe in the water of the other, for example. So, um, let's see. Yeah, I mean, I think I've mentioned this. So again, this is the system of checks and balances. The idea, of course, is that no branch of government fully exercises control. Note in a parliamentary style of government, the UK, uh, Canada, a number of others, they have two, right? Because the legislative and executive are effectively one, and then there's the judiciary, because the leadership of the ruling party in parliament takes on the role of things like the prime minister, the foreign secretary, the home office secretary, etc. But we obviously have three specific ones. Um, Wanted to chat a little bit about judicial branch support agencies because, just one other thing. We've covered what's provided in Article 6, but in the California Government Code, which talks a lot about state government, whether it's legislative branch, executive branch, local governments, a lot of specificity there. The same with the courts. So in Title 8 of the California Government Code, over 14 chapters, 1 through 14, there is a tremendous amount related to the organization and the governance of the California court system. So yes, it's established and granted its authority in Article 4, but there are hundreds of provisions regarding fleshing out the organization, the three levels of the courts, and how they're operated and governed in the state. That's all in the government code. Those are all statutes enacted by, of course, the legislature and the governor. So, um, if you want to find out really how the court system operates, that's really in the California Government Code. Okay. Um, Corey certainly spent a fair amount of time on the Judicial Council. That's where he works. But a couple other ones. I mentioned early the Commission on Judicial Appointments. So again, their job is to review and vote on the gubernatorial appointments to all the appellate courts in the state, not the Superior Court or trial court, only the courts of appeal and the Supreme Court. Remember, this commission takes the place of the Senate. Okay, so the Senate in California confirms like 4,000 gubernatorial appointments from agency secretary, department heads, boards and commissions, all that kind of stuff, but not members of the judicial branch. At the federal level, the US Senate does all of it, presidential appointments, including members of the judiciary. All right. The Chief Justice, the Attorney General, and again, the most senior presiding justice on the Court of Appeal for a Court of Appeal appointment, or the state's most senior presiding justice of all the courts for a Supreme Court appointee. When an attorney is nominated by the governor, again, the Jenny Commission reviews, and then the Commission on Judicial Appointments holds a public hearing, and their credentials, their qualifications are actually aired in public. And they have generally always supporters, but if there were a detractor or an opponent, they could appear and speak as well. There's also the Commission on Judicial Performance, and they basically oversee the conduct of judges, and it's an independent state agency, and they are tasked by the Constitution in Article 6 to investigate any complaints of misconduct against a California judge or justice. So whether it's a trial court judge in Sacramento or San Diego, Court of Appeal justice, or one of the 7 California Supreme Court justices, it's their job to investigate those complaints. And they are granted by the state constitution the power to discipline those judges. So, what happens when a charge is filed against a judge? The commission is required to actually conduct a public hearing. So, it's not, those charges are not heard and considered in secret. They're actually heard in a public hearing. And they have authority to do one of three things if they find that a judge or justice has in fact engaged in misconduct. They can remove a judge or censure the judge. What are some of the things that the Constitution specifies is grounds for removal or censure, which is basically a public reprimand, willful misconduct in office, persistent failure or inability to perform their duties, habitual intemperance in the use of intoxicants or drugs, or conduct prejudicial to the administration of justice that brings the judicial office into disrepute. They can also publicly, in a harsher case, or privately, in a less harsh case, admonish a judge for any failure or for engaging in an improper action or dereliction of their duty. And then the last power that they have is the ability to actually retire a judge or justice for disability. That's only in cases where that disability, quote unquote, seriously interferes with the performance of the judge's duties and is or is likely to be permanent. Now, is there any review mechanism for the Commission on Judicial Performance? Yes. If they propose removal, censure, admonishment, or the retirement of a judge, the ruling automatically, the commission's ruling that is, automatically goes to the Supreme Court, who has discretion to review that proposed action. And if they don't overturn it, then the commission's action, takes effect. It's interesting who comprises the commission because it's not just the judiciary, okay, policing themselves. The 11 members are 3 judges appointed by the Supreme Court, 4 appointees by the governor, 2 must be attorneys, and 2 must be non-attorneys, 2 public members by the Assembly Speaker, and 2 appointed by the Senate Rules Committee. So the legislature also, so they get 4 members, the governor gets 4 members, and the Supreme Court gets 3 of them. The Judicial Council, as Corey talked about, is the policy-making branch, or sorry, the policy-making entity for the court system. And remember, it's established in the Constitution. In fact, there are 3 sections, 4, 6, and 12 of Article 6, that discusses the role of the Judicial Council. And the council also has numerous programs and different types of projects to develop strategic goals and different initiatives for the judicial branch, which are often talked about each year by the Chief Justice when she gives her State of the Judiciary before the California legislature. The governor and other constitutional officers almost always attend that State of the Judiciary, but it's delivered like the State of the State historically has been done, except for the last few years, by the governor in front of the legislature. The Chief Justice does the same thing. The Chief Justice also sets forth any legislative priorities as well as budget priorities. So the council, of course, is chaired by the Chief Justice, and that it employs a staff, and they have numerous committees that talk about things like their budget, technology, managing litigation in the courts. And they've got like 24 task forces that includes both members of the judiciary and members of the public. Things like small claims court, their facilities, interpreters, court security, family and juvenile law, traffic court, probate, and all those types of things that look at things like their workload and whatnot. As I mentioned before, yeah, they play a role, the courts do, in lawmaking of legislation, right? In their review. They also review regulations. In fact, it's specified in the California Government Code that any party, so it's not that you have to be directly affected by a regulation. It says any person basically can go to court to obtain a judicial ruling in trying to validate or invalidate a regulation adopted by any of those 220 or so executive branch agencies, departments, boards, commissions, bureaus, etc. They bring what is called an action for declaratory relief before a California trial court or the Superior Court. So there's actually a role for the judicial branch in the rulemaking process as well. You may have heard, perhaps, a legal notion called exhaustion of administrative remedies. And the idea behind that judicial doctrine is to say, hey, before you can go to court, if there's an administrative process, like all of those businesses and professions that are licensed and regulated, again, medical board, funeral directors, etc. They have to go through the administrative process that is set forth in the the requisite statutes, primarily in the Business and Professions Code, but elsewhere too, before they can go to court. In challenging a regulation, you don't have to challenge it before the administrative body. In other words, if they're proposing a new regulation and you think it violates the law, you don't have to petition that agency and say, "Oh, I don't think this is lawful or something." You can go straight to court. So there is no exhaustion of administrative remedies limitation when it comes to getting a judicial determination of whether or not an agency's promulgation of a regulation is lawful or not. What are the bases for the judiciary to overrule a regulation? The primary one, and you'll get an understanding of this in our second course when we get in depth with the rulemaking process. No, sorry, that's number three. The next one is lobbying and budget. Sorry. The number three is the Administrative Procedure Act. The APA, same at the federal level or similar. It's based on the federal APA, and all 50 states have an APA equivalent. It's basically the process by which our 200 plus executive branch entities have to follow in order for them to properly adopt a regulation. So the main ground is for finding a regulation invalid is for what's called substantial failure to comply with the APA. There are some other bases, but that's the main way of invalidating a regulation. Um, there are some other ones, including the agency's determination whether or not the regulation was quote unquote reasonably necessary to effectuate the purpose of a statute or other provision of law, or that the agency's determination in making the rulemaking is quote unquote in conflict with substantial evidence in the record. Now, a court in reviewing a regulation or a rulemaking is limited in its consideration of certain evidence. So they can only, sorry, I should have brought some water. They can only consider four types of evidence. One is the whole rulemaking file, and again, we'll get into this in class three, but the whole rulemaking file, all the evidence, all the public comments, all that stuff that goes into adopting a regulation or amending one by that rulemaking body. Again, resources agency, the Department of Motor Vehicles, et cetera. They can also review the finding of an emergency if a rulemaking agency adopts what's called an emergency regulation versus a regular regulation. Any type of information that wasn't properly included in the rulemaking file, and then any evidence that's relevant to whether or not the regulation was properly adopted under the APA. So again, that's done by a filing in Superior Court, and the court makes a determination regarding the validity of that regulation. I think the last thing I wanted to just touch upon is the fact that the California Public Contract Code has a whole bunch of provisions related to contracting by the judicial branch. So one of the 29 California codes that Katie mentioned Monday night, one of them is the Public Contract Code. And it's not a huge code, as you might imagine, but it's got a lot of stuff. The Public Contract Code has a whole section on judicial branch contracting. And basically, it authorizes the judicial branch and its entities like the courts themselves, the Judicial Council, and others for them to enter into contracts to provide different things. The most common, different goods and services, certainly when it comes to IT. Now, there are some checks on that. So in the public contract code, any contract entered into that's valued at $1 million or more is subject to review by the Bureau of State Audits to ensure that the judicial branch entity that's entering into that contract has complied with all of the provisions of the law. And the judicial branch that's doing that contract is required to notify the state auditor of any such contract, and then they go through it. There's also a certain review of IT projects by the courts for at a value of 5 million or more. Those have to be reviewed by California's technology agency. And then the judicial branch also has to comply with our procurement and state contracting laws whenever they want to construct or renovate a courthouse, any court buildings, any buildings used by the judicial branch, they all have to comply with the public contract code provisions that apply to state government generally when they procure services or contract, again, when it comes to constructing facilities or renovating them or anything like that. So I think that's the main, yeah, I think that's the main stuff I think I wanted to cover at this point on the judicial branch. So we're almost at the hour mark. Are there questions from folks on the judicial branch or other stuff for that matter, if you want to cover it?
I mean,
Yes, ma'am.
I don't really have questions.
Okay.
It's more like a comment. It's
Okay.
the overwhelming information. It's a lot. It's a lot to take in, and then
Yes.
there's a lot of small details that brings it all together, and it's all making sense, you
Oh,
know?
good. Okay,
Yeah.
good. Well, in theory, look, in theory, and granted, you're getting, 6 week high level things, but the idea is you have the readings,
Yeah.
which gives you you know, a broad insights into branches of government, the budget process, the rulemaking process, et cetera, that we'll get to. And then you have a guest lecture in mine, to try to maybe fill in some gaps, address questions and all of that. And then, through your brief quiz and discussions, you get your fingers, into it a little bit. And then obviously in your 2 to 4 papers for each of the 4 classes, you're doing a little bit of independent research, and putting together your own thoughts. So hopefully at the end, no, you're not an expert on a branch of government, but you certainly have a pretty good understanding, and at least you know where to find information beyond the Google, obviously.
Oh yeah, yeah,
Uh, you
sure.
know, whether it's going back to the book or um, you know, maybe remembering that, branches of government are in the Constitution and the government code, or, little things like, you know, there are 200 agencies that make rules, or the Judicial Council is the one that formulates policy for our court system. You're not going to remember every item, but at least have, some basis as to some of the inner workings of California state government. That's the way the certificate program has been established and is trying to work. And obviously, at the end of this program, when you earn your professional certificate, we're also going to ask for your, candid feedback in terms of, did this do what it was supposed to do? And are there ways of modifying it? As I said the other night, a lot of you, for good or bad, are sort of the guinea pigs in the sense that you are the first cohort, right? You're the first group to go through this. They're going to do two more next year and do two every year thereafter. You're the very first to go through it, and we'll certainly request and hope for your feedback in
Yeah,
terms of what's presented. And so,
no, I personally appreciate it. I was raised in Dubai, so politics was extremely different.
oh yes, I'm
So
sure.
so this is all like, oh my gosh, like it's new information. It's very useful to understand like where I'm living here today, how everything
Yeah.
works. So
Oh,
it's
fabulous.
the
Okay.
contrary, yeah. So thank you.
Yeah. Of
Yeah.
course, of course.
I actually, specifically with the judicial branch, was
Yeah.
incredibly shocked in comparing kind of our system for evaluation and I guess disciplinary action compared
Okay.
to the federal level. Because it does seem like we have more opportunities to we have the opportunity as a retention election, right? But
Yeah.
also there's just a system to hold judges accountable that you don't
Yeah.
really see at the federal level, and
Yeah.
it
At
has
the federal
become
level,
very political now.
sure. Well, and at the federal level, the only thing that you have is impeachment. And impeachment is not like you don't like their rulings, you know? So yeah, all you can do at the federal level is impeach a judge. So
Yeah, and very few judges from what I saw have ever been impeached at the federal level. I think
that is correct.
it was
Yes,
like
ma'am.
15 were impeached and only 8 were ever removed. And it just, with how many
Yes.
judges we have, it does seem like a very big flaw in the system that there's really no disciplinary action. It's very hard to remove somebody.
Well, you may have read, well, in the last couple of years, there's been a lot about the ethics of Supreme Court justices. And there's been, talk about basically, uh, well, I think it was Justice, not Souter, who was it? One of them, one of President Trump's appointees, said, Congress can't create an ethics code for us, only we can. Um, and, we're basically the only ones who can discipline ourselves. For example, all of the failure to disclose Justice Thomas's, trips on private airplanes and resorts of, friends who had business before the courts and all that kind of stuff. I mean, uh, those are the types of things that you could be removed from office quite readily in the state of California. But obviously at the federal level, is the Congress going to impeach you over that? Undoubtedly not. Um, anyways, discussion for another day, but yeah, I agree with you. Anything else? Any
Well,
questions?
to go back to her point, is there a way to change that? Is there an
Of course, but remember, it's just like the 27 amendments to the United States Constitution, right? Um, two, two-thirds of the states have to ratify an amendment to the Constitution. So it's not like we don't have direct democracy at the federal level. So remember, at the state level, if we get the requisite number of signatures, we can place a measure to create a statute or change or add to the state constitution, and the voters vote on it by majority vote. That's not what the federal constitution provides. So it's a very cumbersome, process. And that's why it's only been amended 27 times. California's over 500. So it is possible, but very difficult and very time consuming. And again, you'd have to get all those state legislatures and governor to agree. So tomorrow night's our last one. Well, for this 6-week session, sorry, there'll be more starting soon. In fact, yesterday I had lunch with the two presenters, the 13th and the 20th, I think, of August for the two lobbyists. And then we will have the budget director for the state Senate leader talking about the budget process. So in the next 6-week program, as opposed to this one where we covered 4 big topics, we're covering 2 big topics in the next 6 weeks, lobbying and the California budget process. That also means you'll only have 2 quizzes and 2 essays for those who are counting. But you'll actually have 2 lectures from me and 3 guests. So 2 on lobbying and 1 on the budget process. So you'll have 5 lectures during those 6 weeks and 2 essays and 2 quizzes. There will be there'll be 3 in the next one. And then in the 4th and final certificate course, there will be back to 4, which also means 4 quizzes and 4 essays. So later in the year, again, for those who are accounting. So tomorrow, just note tomorrow it is from 4 to 5, because I teach in person in the evening. So that's why it's an hour early. If you can't make it, it will be recorded. That's one thing. 2 things. Because somebody asked yesterday. Okay, number 1 is they're allowing me to publish the course that begins on Monday, so I'll do it later tonight for those who want to at least take a look. And then number 2, sorry. The lectures from 1 and 2 were updated. I haven't looked in your Canvas, but the Merced person who helps me with the Canvas site, she said they're under that section. So Mondays from Katie should be under the 4th section, statutes and the Constitution. And then yesterday's on the executive branch should be under the executive branch section in your Canvas site. Tonight's will go under judicial and tomorrow's under local government. So that's where she said they placed them. But those 2 are up. And tonight's and tomorrow's will be up the following day, she said. So there you go. All right.
Thank you.
Thank you all. We'll see many of you tomorrow. Okay, take care. Bye.